Today's guest is Eric Olsen, the founder of Helps Law Group, a nonprofit law firm that protects seniors, veterans, and disabled Americans from aggressive debt collectors. A bankruptcy attorney with more than 40 years of experience, he helps seniors understand when their Social Security and retirement income are legally protected, often eliminating the need for bankruptcy. His mission is to help older Americans protect what they've earned and live with greater peace of mind.
What happens to your pensions and Social Security if you file bankruptcy? I'm here with Eric Olsen, bankruptcy attorney for 48 years. Eric, tell us the details. What happens?
Nothing. You keep getting it. It's protected. It's nothing to worry about. Okay? Trustee can't take it. It's exempt under federal law or state law, so is your Social Security. I mean, you could even have $10,000 in Social Security you've saved up and filed bankruptcy, and trustee couldn't touch it.
So wait, that's interesting. I didn't know that. So you're saying if I receive Social Security income of $1,000 a month for 10 months and I didn't touch it, the trustee couldn't take that either?
No, it's protected. As long as you can trace where it came from. The federal benefit, Social Security, is protected, period. A guy might get a lump sum payment, from Social Security, but he's got all these other problems, and he keeps that $30,000 from the lump sum payment for Social Security disability. Then it took a while for him to get it. Just keep that in a segregated account. You can file bankruptcy. You got that $30,000. No one's going to take it. Your pension, your Social Security is protected. It's not the only way that it's a problem in bankruptcy, and then it's even not a problem. They have to qualify for bankruptcy now. They have what's called a means test. If you make too much money, then they might have to put you in a Chapter 13, and your Social Security normally does not apply to the means test, and a pension possibly could, okay? So there could be a problem if you had a huge pension plus other income, make it so you don't qualify for Chapter 7. But as far as you losing any of that money, no, it's not going to be a factor.
This includes when people have retirement accounts that they consider paying off debt, right? So if you file bankruptcy, the last thing you want to do is pay off debt that with your retirement. If nothing's going to happen to it, I want to speak 30 days prior, 60 days prior to the bankruptcy. You definitely don't want to pay off any debt if they can't take that. You don't
they can't. You're talking about your 401k or your IRA or your different private. No, they're protected. You file bankruptcy, no one can touch that.
So this is all part of the bankruptcy law. The way the laws were written is to not wipe people out completely. See, bankruptcy is more of a legal reset. It's like it's a breath of fresh air. It's some space for you to rebuild. It's not a wiping out like a scorched earth to your financial situation. Still keep your retirement, keep everything.
Yeah, and your assets. You have state law to keep your assets, and then, but I guess if you're a senior, you should also realize too that you may not even need to file bankruptcy.
Yeah,
absolutely. You may not be able to afford to file bankruptcy, and you say, "Well, what do I do?" Well, creditors can't, even if they sue you get a judgment, they can't take your pension or can't take your Social Security. They could call, but then there's the Fair Debt Collection Practices Act that provides if you send what's called a cease and desist letter, the debt collector can't communicate with you anymore. Now they could sue you, they get a judgment, but you're judgment proof. They can't, your income is protected, So there's a lot of reasons why, your income may be protected in bankruptcy, but you don't even need to worry about bankruptcy in the first place.
So we're talking about pensions and Social Security. Outside of bankruptcy, it doesn't matter. Like the debt collectors can't come get it.
No, that's true. Now, if you have more than twice the amount of a federal benefit like Social Security in a bank account, and someone sued you and got a judgment and they garnish that bank account, they could hold up the excess money in the account. And you'd have to file a challenge to garnishment or claim exemption to have the court release that money. So you could prevent that from happening by just making sure you never have more than twice the amount of your Social Security or your federal benefit that you get each month in your bank account, so that no one could take it. So then you might say, well, what do I do with this extra money I have, Eric? Well, a lot of people don't have that extra money.
Mhm.
But if you did, maybe the debt's just on the husband, and then he could, let the wife hold the money. Or he
And
could
yet,
get a preloaded debit card or cashier's checks. No one can garnish those. I mean, there's different things you can do if you had excess money to protect it.
Eric, thanks for your time. Thanks for your information. If you have any questions, comment below.
If you need assistance, contact Eric at 855-435-7787, or to be connected to a bankruptcy attorney in your state, use the resources link in the description of this video.